234 talks about director is a person who is appointed to the board. So, what is the role of director in a company? Director is having 5 roles. First one, director should act in what kind of position? Fiduciary position. Fiduciary position is a position which is a relationship with trust and confidence. And in the given case, who is trusting whom? Directors are trusting shareholders, huh? No, shareholders are trusting directors. That is why that kind of powerful position has been assigned by shareholders to the so-called directors. And the second one is decision maker. Obviously, directors will take the decisions. And the third one, day-to-day decisions. Day-to-day decisions obviously taken and executed by directors only. But when it comes to strategic decisions will be taken and implemented by directors in consultation or according to MOA and AOA. If directors are having such powers, they will take obviously. Otherwise, they will take the approval from shareholders by conducting AGM or EGM. That is a different thing. And the third one is compliance officers. Compliance officer means complaints means compliance means following the rule. Company is a dash person, artificial person. Company on its own can't comply with rules and regulations and laws. Directors should make sure that company is obeying and complying all the rules and regulations. The fourth one is strategic planner. Last but not least, fifth one is representative. So these are the points we have completed in yesterday's discussion, and minimum number, maximum number also completed 1, 2, 3 and 15, and beyond 15, 1 for minimum number, 1 for OPC, 2 for private company, 3 for public company. When it comes to any other company or any company, not other company, any company, maximum number is 15. And is there any prohibition with respect to appointment of directors beyond 15? No, there is no prohibition, but in order to appoint more than 15, you have to take the approval of shareholders by passing which resolution? Special resolution. Okay, so yesterday we have discussed what is a ordinary resolution and what is a special resolution. 3 times of the vote, more than 3 times of the vote you have to get in favor than votes casted in to against. Okay, and last but not least, types of directors. Actually, types of directors discussion is going. Executive directors completed, non-executive directors completed, managing director completed, whole-time director completed, independent director I should discuss. So before I'll discuss independent director, I have to discuss who is nominee director. Who is nominee director? I'll discuss. So nominee director. So do you know anything related to nominee director? Who is a nominee director? If anybody knows, tell me. Who is a nominee director? Very good. Proxy. His behavior is like proxy. Very good. But do you know who is a nominee director? Simple ma. Nominee director is a person. Nominee director is a person who came into the board of the company to represent someone else. Say for example, there is a company called XYZ Limited. What is the company ma? XYZ Limited. This XYZ Limited company is planning to take a loan from State Bank of India. State Bank of India placed a condition saying that yes, we are ready and willing to provide the financial assistance or loan, whatever asked by you, we will provide. But lot of companies are not in financial disciplined manner. whatever the decisions taken by the companies, we don't know. Why? Because we are not having any role in the board of the company. Now we wish to change. We wish to participate in your board meetings. We wish to know about what is exactly happening with your companies. We wish to know the managerial activities and all. Indirectly, or in other words, State Bank of India is saying that we wish to have a representative. We wish to have a representative in your board. So now State Bank of India is to have one representative in XYZ Limited's company's board of directors. That is why State Bank of India will suggest Mr. A as nominee director. These are the terms purported or proposed by State Bank of India to provide whatever the loan which has asked by or requested by XYZ Limited. Say for example, for this condition, if XYZ Limited agreed, what will happen? For this condition, if XYZ Limited agreed, what will happen? Mr. A will occupy a chair in the board of directors of XYZ Limited, and that person will be called as nominee director. So nominee director is not acting on his own behalf. His job is to protect the interest of the person who is actually appointed. Who is the actually appointing authority? State Bank of India. State Bank, according to the suggestions made by State Bank of India, XYZ Limited appointed Mr. A as a director. That is nominee director. So State Bank of India nominated Mr. A as a director. So this person gets nominated by someone else. Generally, that someone else is banks or financial institutions or group of creators or group of money lenders, or generally who will nominate means banks, financial institutions or group of creators. These people will nominate one educated, experienced person to act as a nominee director in the board of debtor company. Board of which company? Debtor company. So this person is called as nominee director, and in simple, or the job of the nominee director is to protect the interests of the person who is nominated. Okay, the job of the nominee director is not to act according to the interest of the company. His job is to protect the interest of the so-called person who is nominated him. In the given example, State Bank of India nominated Mr. A. That is why it is the job of Mr. A to protect the interest of XYZ Limited or State Bank of India. State Bank of India. If any decision taken in the board of directors of XYZ Limited against to the interest of State Bank of India, immediately he will elect the so-called money lender, State Bank of India. Then State Bank of India will take respective action. That is the job of nominee director. Sir, why nominee director discussion has taken as a frontline discussion before the discussion of independent director? Why? Because independent director should not be a nominee director. Independent director should not be a nominee director. That is the rule. That is why in order to know about independent director, you have to know who is a nominee director. So this guy is a nominee director. So first of all, let's quickly read out nominee director. As per section 161 subsection 3, a director nominated by generally financial institution, bank or government as per law or as per agreement. I have taken a simple example. In that example, State Bank of India is nominating Mr. A due to agreement. What kind of agreement? What kind of agreement is there between X Limited and State Bank of India? Simple loan agreement is there, In order to protect the interest of State Bank, Mr. A will work in the board of XYZ Limited. Simple. So Nominee director is a director who is nominated by financial institution or bank or government as per law or as per agreement. So the position of nominee director may be derived by an agreement or by a law. Maybe by an agreement or by law. Okay. Say for example, sufficient. Next, appointed by which parties, ma? Third parties such as creditors or debenture holders like that. Next, their role is to protect the interest of nominating party, not to protect the interest of company. Not to protect the interest of company. Any director will be act. What that is the first point. First point, no. Out of 5 points, first position is fiduciary position. Fiduciary position means fiduciary relation means relationship with trust and confidence. So shareholders are trusting these directors and appointing them into the board of the company. This is how generally appointment of directors will happen. But that is not the case in case of nominee director. Why? Because nominee director is not appointed by shareholders of the company. Nominee director's appointment is done by someone else. Generally, that someone else might be banks, financial institutions, trusts, government, like that. That is why their job is to protect the interest of the nominating party, not to protect the interest of the shareholders or company, whatever it may be. Okay, so this is nominee director. Everybody clear? Who is a nominee director? Everybody clear? So now let's have a discussion related to independent director. So an independent director is a director other than MD. Yesterday completed. Who is an MD? Other than WTD. Yesterday completed. Who is WTD? Other than nominee director. Just now we completed the discussion relating to nominee director. That is why nominee director discussion has been promoted to earlier discussion. So an independent director is a director other than MD, other than WTD, other than nominee director who is not related to promoters or management. There should be no relation between company and independent directors. Then only you will be properly qualified to act as a independent director of a company. And applicability norms for listed companies mandatorily applicable irrespective of your turnover, irrespective of your paid up share capital, irrespective of anything. If you are a listed company, then independent director applicability will be there for you, and you have to maintain at least 1/3 of total directors as independent directors. How much, ma? 1/3 of the total directors as independent directors. Actually, not only 1/3, in some cases, those listed companies has to maintain half of the board as independent directors. Actually, in future, you will get to know when these norms will be applicable. Actually, these norms are applicable by the rules stipulated by SEBI according to LODR. Listing obligation and disclosure requirement norms are there. SEBI LODR. So you will get to know about these LODR norms at a later point of time, somewhere around CGCSR topics. Corporate governance and corporate social responsibility norms will be there. Na? At that time we will discuss. Why? Because these norms are stipulated by Kumar Mangalam Birla Committee. Right away, these norms are implemented by SEBI in LODR norms. What will happen if, according to SEBI LODR norms, means I'll tell you. Actually, very interesting. Say, for example, you are a listed company. Whether you have to maintain 1/3 board, at least 1/3 board of directors as independent directors or half of the board as independent directors depends upon the behavior of your chairman. So one company is there, listed company. For that one company, obviously chairman is there. Or no chairman there. No chairman is there for listed company. At least MD will be there, no? I have to check. Generally 100 out of 100% cases chairman will be there, or combinedly CMD will be there, chairman come managing director. Chairman come managing director, CMD, chairman come managing director, 100% it will be there. So chairman is there. Kindly observe the behavior of chairman. Observing the behavior of chairman means not to observe the facial expressions of chairman and all. Kindly observe the position. Observation means observation of position. So whether he is a executive or he is a non-executive, kindly confirm it first. Sir, I confirmed, sir, that so-called chairman is an executive chairman, sir. Why I am discussing means you know who is a executive director and who is a non-executive director. How you will know? Yesterday only we have completed the discussion relating to who is a executive director and who is a non-executive director. That is why I am prolonging the discussion. Actually, I supposed to tell this discussion at a later point of time, but no offense. You will be able to understand. That is my guarantee. Listen carefully. So, if a chairman is an executive chairman, chairman is a executive chairman, chairman is an executive chairman, then the so-called listed company has to maintain half of the total board of directors as independent. Say for example, if 10 members are there, if 10 members are there, at least 5 members should be independent directors. 5 members should be independent directors. When if the chairman is a executive chairman. Chairman is a executive chairman. Sir, chairman is a non-executive chairman, sir. I'll tell you. Don't worry. I'll tell you. Discussion is not completed. I'll tell you. Listen. Sir, chairman is a non-executive chairman, sir. Chairman is a non-executive chairman. Then you have to check another point also. What is the point? Is the chairman related to promoter or promoter group? Check this point first. Is the chairman is a related party to promoter or promoters group? Yes, sir. This chairman is related to promoters group. Then same rule. Maintain half of the total strength of board of directors as independent. As independent. Sir, the so-called chairman is a non-executive chairman is there, no? That non-executive chairman is not a related party to the promoter or promoter group, sir. He is a third party. He is independent from promoters. There is no substantial relationship between the so-called promoter and the non-executive chairman. There is no relation, sir. He is just working like an employee. No substantial or no financial relation is there. Then same rule. What is the same rule? Non-executive chairman and not related to promoters or promoters group. Then 1/3 of total strength of board of director. Maintain 1/3 of total strength of board of directors as independent director. That is enough. Sir, I will maintain more than 1/3. It is your karma. Maintain, no problem. So this is what the provisions are saying. Okay, so we'll discuss one more time and I'll explain you the logic also. Why Kumar Mangalam Birla committee came up with these norms and why SEBI immediately implemented, and what is the basic point behind the legislation of this rule and all, I'll tell you. So first of all, there is a company. Okay, very good. That company is a listed company. Then only we will care about these norms and all. If it is an unlisted company, SEBI rules, why SEBI rules will be applicable for a unlisted company? These norms as per SEBI LODR norms, no? What is LODR norms? Listed obligation and disclosure requirement norms. SEBI LODR norms. Okay. One listed company is there. Very good. Congratulations. One listed company recently formed. Check out whether the chairman is a executive chairman or a non-executive chairman. That is the first thing you are supposed to do. Chairman. First case, executive. Second case, non-executive. Ma, what is our rule, ma? If chairman is a executive chairman, half of the total strength of board of directors is equal to independent. This is the minimum rule. Minimum rule. Say for example, if 10 directors are there, you have to maintain at least 5 directors as independent directors. Sir, I'll maintain 6, sir. No problem. I'll maintain 7. No problem. I'll maintain 8. No problem. I'll maintain 4. There is a problem. So you should not maintain less than 50%. I'll tell you. I'll explain the logic also. Next one. Sir, the chairman is a non-executive chairman, sir. Now, one more point you have to check. Check whether chairman is a related party or a related person to promoter or promoter group. Then also same rule. Half of the total strength of board of directors is equal to independent director. You have to follow the same rule. Okay. Sir, second case. Not related, sir. Then exemption. Just maintain 1/3 of the total strength of board as independent director. It is well and good. Why these rules are implemented? Listen carefully. You know about executive and non-executive, right? Tell me, who is an executive director? Who actively engages in the day-to-day affairs of the company? Those kind of directors will be called as executive directors. That is the thing, no? That means executive directors are going to place a crucial role in the administration of the company. In other words, the involvement of executive directors in the administration of company is very high. The involvement of non-executive directors is very low. Why? Because they don't generally participate in the day-to-day decisions making and all. They will participate in the policy making decisions, policy making meetings. In that crucial meetings only they will participate. Other meetings they will avoid. That is the rule, and that is the concept which we have already discussed in the yesterday's session. Listen carefully. First of all, chairman is an executive chairman. I have already told you that generally listed company CMD will be there, and majority of the cases chairman and managing director used to be same person. I have already told you in the previous session that managing director is a person who is going to have the substantial powers of management of the company. That is the thing, no? That means power is concentrating only at the one person. In majority of the cases, chairman and managing director are the one and same person. One person. Chairman is there and he is an executive. Chairman is there and he is a executive. Listen. Chairman, obviously powerful person. And this so-called powerful person is taking place or playing a crucial role in the day-to-day affairs of the management of the company. Then what will happen? Say for example, a fire accident is happening, ma. Fire accident is happening. To that fire accident, air will add as a catalyst or not? Who is a catalyst or what is a catalyst? Catalyst is an element which ignites the process, which will speed up the process. Obviously, if air added to the fire, obviously the intensity of the fire accident will be more and more. That is the same which is happening here. Chairman obviously is powerful person. To that powerful person, one more position is adding, that he is an executive. That means the substantial decision making authorities and substantial powers of the company is situated with only one person. My company's interests are one single person's interest. It's a collective interest of lot of people. Company's interests are the collective interests of lot of people. Why? Because on company, not only shareholders, lot of groups, are directly or indirectly deriving their livelihood by depending upon the company. That group we will generally call them as stakeholders. Stakeholders. So that is why definition of stakeholders or the purview of stakeholders is way more than the definition of shareholders. If you have shares, then only you will become a shareholder. If you have shares, then only you will become a shareholder. Even though you are not having any shares, you may become stakeholder. Employees, creditors, or shareholders, and society, everybody will become stakeholders. Listen carefully. Company, say for example, listed company means it is a somewhat substantial company or a suitcase company or a substantial company. Lot of stakeholders are depend or a lot of people are drawing their livelihood by depending upon this company. But the fate of the company is situated with this so-called chairman. Why? Because substantial powers are vest with chairman only, and the chairman is not a non-executive chairman. The chairman is a executive chairman. That means he is going to have a clear-cut idea and a picture about what is exactly happening with the company. In other words, in simple words, we can say that he is the powerhouse of the company. In order to balance this powerhouse, or in order to add counterbalance, this rule has been implemented. What this rule is saying, half of the board of directors, at least, this is minimum rule or not maximum rule, at least half of the total strength of board of directors should be independent directors. Then what will happen? Say for example, if these kind of measures are not there in the company, then chairman will drive the company in whatever the direction he may want. If he is a good person, by chance the company will be saved. If he is a bad person, obviously the company's financial resources or reputation is going to be tarnished. That is why, in order to save from the mad actions of the so-called chairman, counter powerhouse should be there. If one powerhouse is there, it has to be matched with another powerhouse. The another powerhouse is nothing but half of the board of directors. That half of the board of directors is equal to independent directors. Then what will happen? Whatever the decisions taken by, even though those decisions are mad actions, those decisions should not be implemented. Why? Because counterbalance is there. Independent directors will protect the interests of the company. This is one point. Second one, sir, chairman is there. That chairman is non-executive chairman, sir. Non-executive chairman means, is he going to actively engage in the affairs of the company? No, but he is related to promoter, sir. Whenever the so-called non-executive chairman is related to the promoters or promoters group, again, powerhouse is forming a. Why? Because he is a chairman, obviously he is having some powers. Even though he is non-executive, he is related to promoters. Non-executive means somewhat powers are reduced. Why? Because non-executive directors will not engage in the day-to-day affairs of the company. So chairman, obviously powerful person. Non-executive, okay, somewhat powers are reduced, but he is related to promoters. Powers are not reduced, powers are increased. That is why same, in order, a powerhouse is forming here. In order to counterbalance this powerhouse, same rule is implemented. What is the same rule? Make sure that half of the total strength of board of directors should be independent. Coming to last case, chairman, non-executive, not related. That means substantial powers are not there with the chairman. Why? Because he is a non-executive chairman. He is not going to play a crucial role in the day-to-day affairs of the management. Why? Because he is a non-executive. Even though he is a chairman, he is a non-executive. He is a non-executive chairman, and he is not related to promoters also. He is not related to promoters also. Then substantial powers are not vested with the chairman. No need to counterbalance the powerhouse and all. Why? Because he is not a powerhouse. So minimum restriction is enough. What is the minimum restriction? 1/3 of board of directors is equal to independent directors. We'll discuss more why Kumar Mangalam Birla committee has implemented, suggested these rules, and why immediately SEBI implemented by clause 49A. This will be called as clause 49A regulations. SEBI LODR clause 49. What is clause 49 and all at a later point of time. CGCSR topics we will discuss. Okay. As of now, you have to remember this thing. Okay, so why I am discussing these things means you have to know the relevance and significance and importance of independent director. Independent director is not a dummy. Independent director is a powerful person. Okay, so let's know more facts and more interesting things about independent director. First one. So an independent director is a director. Okay, very good. Other than and so why this point has been framed not related to managing director, not related to executive, not related to nominee, and not related to promoter means, what is the name? If he is related to promoters, where is this point? If he is related to promoters, independence will be affected. He choose to take biased decisions. Manadle gada. Biasness will be come in the decision making matter. That is why you should not involve related persons in the role of independent director. That is the basic rule. And the nature of the independent director is non-executive. The nature of the independent director is non-executive. These guys are, yesterday we learned MD and WTD. MD. Read this point, Involving in day-to-day management means he is a, what is the nature of ID? ID ante independent director. What is the nature of ID? He must be a non-executive director. But this guy is a, and whole-time director is a, apart from executive director, he is a slave. He is a full-time employee of the company. That is why you can't expect independence from whole-time directors. That is why independent director must not be a MD, WTD or nominee director. Sir, okay, I understood, sir. Independent director should not be MD. I understood the logic. Why? Because the role of ID is a non-executive and MD, WTD are executive. That is why specially prohibited. That is okay. So then why nominee director, independent director should not be a nominee director? Tell me. Okay. Excellent. That is the point. Till this time, what we are discussing, independent director are those persons or such kind of powerhouses. They should protect the interest of shareholders. They should protect the interest of shareholders. Why? Because if chairman is doing any mad things with the company and all, it is the responsibility of the independent directors to stop the execution of the so-called mad decisions and to protect the interest of shareholders. It is the job of the independent directors to protect the interest of shareholders. Whereas what this guy is doing, what nominee director is doing, he is not supposed or he is not expected to protect the interest of shareholder. That means the job role of ND and ID is not same. The job role of ND and ID is not same. That is why ND must not be MD, WTD, ND. So ID must be a person who is separated from managing director, full-time director, nominee director. Are you understanding the logic behind why specifically from ID role these three guys are excluded? That is the thing. And this ID should not be related to promoters or should not be related to management. Why? What will happen if he is related party? Biased decisions. You can't expect independence from the related parties. That is why he should be a unrelated party. Unrelated party. Yesterday I have already told one of my friend acting as independent director. Why? Because he registered in this website, IICA, Indian Institute of Corporate Affairs. Do you know the website? IICA. You can also register, but 20,000 you have to pay. Not to me, ma. Why you are looking at me like that? I am not taking any money. That website is taking money. It will maintain the whole details with respect to the persons who are registered as to the registry or directorate of the database, and company will choose the proper person according to the educational level, background, experience, and all, and place of availability. They'll choose the decision accordingly. All they need is one unrelated party. That is the thing. Thousands of people are there. Sir, I studied BCom, sir. I studied MBA, sir. I studied so and so stream, sir. Am I eligible? If you have 20,000, you're eligible. But whether the company will choose you as an independent director or not, that is at the discretionary powers of the company, and on you, completely depends on your luck factor. That's it. Okay. IICA, if you wish to remember, you can remember. Indian Institute of Corporate Affairs. Very good. Thank you. Next one, applicability. Applicability means, sir, okay, we came to know about who is an independent director. We just know that independent director is a director who should not be MD or WTD or nominee director, or should not be related to promoters or management of the company. It is very clear. For what kind of companies maintenance of independent director is mandatory or required? Means for listed companies, it is mandatory to maintain one third, minimum to minimum, at least one third of the directors as independent. One third. I'll tell you with fractions. What you have to do with fractions, I'll tell you. Okay. Next one. Certain unlisted public companies also there, no? Yes, lot of unlisted public companies also used to be there. For that kind of companies, you have to check the thresholds. You have to check the thresholds. If any of the three thresholds satisfied, if any of the three thresholds satisfied, then those unlisted public companies, even though those public companies are unlisted entities, they are expected to maintain independent directors. Okay, so listen carefully. Certain unlisted public companies, rule 4 of companies appointment and qualification of rules. So what are the thresholds? Paid up share capital 10 crore, turnover 100 crore, outstanding loans or debentures or deposits, how much? 50 crore. Okay, so these entities has to maintain, just a minute, ma. Hmm. 21st date 21 na? Okay. What we are discussing? Unlisted public companies with respect to the maintenance of independent directors by unlisted public companies. So if unlisted public company satisfies any of the given thresholds, no need to satisfy all the three thresholds on a cumulative basis. You satisfy any of the given three thresholds: paid up share capital 10 crore or more, turnover 100 crore or more, outstanding loans, debentures, deposits 50 crore or more. If you satisfy any of the three conditions, then applicability with respect to maintenance of independent directors will be attracted to your entity also. But for you, being you are an unlisted public company, just maintain two directors. It is enough. No need to calculate one third, one fourth, one two, nothing. Maintain two, at least two. Sir, I'll maintain 3 or 4 directors. Okay, well and good, no problem. Minimum you have to maintain two. Minimum Two directors you have to maintain. Who? Unlisted public company. If you are a listed company, 2, 3 not applicable. You have to maintain independent directors. The calculation should be 1/3 of the total strength of the board of directors. Okay. Next, sir, what are the qualifications of the so-called independent directors? Listen, these independent directors must possess integrity and relevant experience. Integrity means honesty. Integrity means honesty and straightforwardness. Okay. So integrity and relevant expertise, and there should be no pecuniary relationship with the company or promoters. This is very, very important. Why? Because what is the name? Independent director. So being he is an independent director, he should act in a independent way, or he is expected to take decisions on a unbiased note. If you are a related party, how you will take unbiased decision? That is why there should be no pecuniary relationship with company or promoters, and you must not be a KMP or employee in the current year or past 3 years. Again, your independence will be affected if you are a ex-employee or a current employee. Say for example, internal auditor is there. You can appoint your employee also as internal auditor, nothing wrong. But is it possible to appoint your employee as a statutory auditor? No. Why? Because independence will be affected. So, in the given case, independent director also, the so-called person whom you are appointing in the position of independent director, that person should not be your current employee or ex-employee. Sir, past employment period, how many days we will consider? 3 years. Okay, so that person must not be a key managerial person or employee in the current year or past 3 years, and he must not be a relative of promoter or managerial persons. So you might be already know why these points are introduced. All these points are introduced to protect the independence of the so-called independent director. That's it, nothing other than that. So tell me, who is an independent director? Independent director is a director other than MD, WTD, or nominating director, nominee director, and listen, and who is not related to the promoters or management. What kind of entities need to maintain independent directors on a mandatory basis? First, listed companies, irrespective of turnover thresholds and anything, if you are a listed entity, you are supposed to maintain independent director. How many directors you have to maintain? 1/3 of the total strength of directors should be independent. If you maintain more, it is okay, no problem. And if you are a unlisted public company, go and check the thresholds first. Paid up share capital threshold 10 crore or more, or turnover thresholds 100 crore or more, or outstanding loans, debentures, deposits 50 crore or more. If you satisfy any of the three thresholds, then you have to maintain independent directors. Minimum 2. If you wish to maintain more than 2, no problem. These are the qualifications. All these qualifications are prescribed for independent directors to protect the independence and unbiasedness of the director. Next, definition and all. So I have summarizedly given all the points in a tabular form. This is definition, which we have already studied. Applicability, which we have already studied. Minimum number, yes. Listed companies, how much ma? 1/3. Unlisted, minimum 2. Next one, tenure. Actually, I have to tell this point. Tenure is, first of all, an independent director can be appointed for a max tenure of 5 years, or for a continuous period of 5 years he is expected to, for a continuous period he is expected to work only till 5 years. Okay, so a term up to 5 consecutive years. And if you wish to really continue with the so-called independent director, you can again appoint him, but only second time appointment, only reappointment one time is allowed. Reappointment, original appointment 5 years, reappointment only once allowed. After that again cooling period will be applicable. Cooling period. Okay, so original term 5 years, reappointment once allowed another 5 years, 5 plus 5 10 years. But you have to observe a tricky thing here. In order to, I'll tell you, listen. A company is there. Company is planning to appoint independent director. Companies in a plan to appoint independent director. Listen carefully, very important. I'll tell you the process of appointment of independent director first. Then I'll tell you the tricky point. So how the independent director will be appointed for a company. It is the job of board of directors to select independent director or to filter independent directors list. Say for example, one company is there, X Limited. This company is going to appoint on a mandatory basis. It has to appoint 7 directors as independent directors. Why? Because the so-called X Limited chairman is an executive chairman, and the company is having 14 directors. What is the rule? If the chairman is executive, then make sure that half of your board of directors must be independent. 14 directors are there. Now few directors will retire in the AGM and all. So at least 7 directors are needed by the X Limited company. For the X Limited is considering 7 profiles for the appointment of which position? ID position, independent directors position. 7 profiles you need. That means at least 20 profiles you have to filter. Minimum to minimum 20 profiles you have to filter. Say for example, మీరు పెళ్లి చేసుకోవాలనుకుంటున్నారమ్మా, ఫస్ట్ సంబంధం పెళ్లి చేసుకుంటారా? So you will keep on searching for various profiles, right? That is not a crucial decision. Is it a crucial decision or it is a regular decision? ఫ్రీక్వెంట్గా పెళ్లి చేసుకుంటారమ్మా మీరు? నెలకోసారి, సంవత్సరంకోసారి అట్లనే ఉంటుందా? సో ఇట్ ఈస్ నాట్ ఎ రెగ్యులర్ డెసిషన్, ఇట్ ఈస్ ఏ irrevocable decision. It's a lifetime commitment. So you have to make sure that you are selecting a right person. Otherwise you will end up in a drum only. Or else, okay, I don't want controversies. So 20 profiles. So it is the job of existing board of directors to filter few profiles. Few profiles. In a numerical basis, I am saying that there is a company called X Limited. X Limited is supposed to appoint 7 independent directors, and in order to appoint 7 independent directors, X Limited's board of directors, existing board of directors, filtered 20 profiles. Sir, from which database they will filter the profile, sir? I have already told you, no? IICA, Indian Institute of Corporate Affairs. From the, it is maintained the entire registry of registered persons. From that person's 20 profiles, the existing board of directors filtered. And generally what will happen, all these profiles will be shown up to the members in a general meeting, annual general meeting. Why? Because annual general meeting, 4 ordinary businesses will be there. Do you remember ordinary businesses which you have studied in CMA Inter? Tell me, what are the 4 ordinary businesses? Very good. Appointment of auditor, appointment of board of directors. First point you missed, adopting financial statement. Without adopting financial statement, how can you declare a dividend? So 4 ordinary businesses. First one, adopting financial statement. Second one, declaration of dividend, if any. It is not a mandatory thing, right? If any, dividend declaration. Third one, appointment of auditor. Last but not least, appointment of BOD. Appointment of BOD. So in this appointment, shareholders will play a crucial role. Shareholders will play a crucial role. That is why existing board of directors will filter few profiles. And place these profiles before shareholders in AGM. General meeting, let's call it as a general meeting. But generally, all these appointments will be carried out in AGM only. And out of the given 20 profiles, members will select 7 profiles, or members will appoint 7 directors by passing obviously OR. OR means for appointment of directors, which resolution is required, ma? Ordinary resolution. Yesterday also I have already made it clear for all of you that don't think that we are appointing a powerful person, special resolution is needed. No, for appointing any director, ordinary resolution is needed. General rule. General rule. There are certain exceptions, I'll tell you. So 20 profiles, board of directors filtered. Out of the 20 profiles, 7 directors members need to appoint. Yes, AGM convened, everybody came, quorum also fulfilled, meeting is carrying on, and members successfully appointed or successfully filtered 7 profiles out of the given 20 profiles, and successfully appointed 7 independent directors to the company by simply passing ordinary resolution. This is how the appointment process will be carried out with respect to independent directors. This is one scenario. There will be another scenario. What is the other scenario? Means members will delegate the responsibility of appointing independent directors to board of directors. Generally, it is the job of shareholders to appoint independent directors. If shareholders are too busy and shareholders are not have that much time to appoint independent directors in the meeting, then what shareholders will do? Shareholders will simply delegate the responsibility of appointing independent directors to board of directors. That means power has been transforming. Power has been transferring from members to BOD. Then what BOD will do? BOD will straight away take the decision relating to appointment of independent directors. BOD will take decision relating to appointment of independent directors. But situation is not completed, or story didn't end here. After the appointment of independent director by BOD, it has to take the approval from shareholders. It has to take approval from shareholders. Why? Because it is the job of shareholders to appoint independent directors. But the job of shareholders is not executed properly. Shareholders transferred their responsibility to whom? Board of directors. Okay, now board of directors somewhat on a successful note, they have executed their responsibility. At least they have appointed some person as an independent director. Now it is the job of shareholders to look whether those board of directors executed the job perfectly or not. That is why it is the job of shareholders to approve the appointment done by BOD. Sir, within which time it should happen, sir? Within 3 months it should happen. Within 3 months it should happen, or in next AGM also it may happen. Nothing to worry. Within 3 months or in next AGM, which meeting came first? Whichever is earlier. Sir, AGM is planning, we are planning AGM next month only, or after 2 months only. In that meeting you have to take the approval. Sir, AGM already done, sir. No AGM, sir. AGM will be again conduct a general meeting, not only AGM. General meeting will be convened after 6 months only, sir. No problem. 3 months or next AGM, whichever, next general meeting, whichever is earlier. So this is how the responsibility will shuffle from one person to another person. Do you get the clarity? First of all, how the process of appointment of independent directors will be carried out? First of all, it is the job of shareholders to appoint independent directors. If they have time, they will simply filter the profiles which are shown by directors. Why? Because first directors will filter the profiles from IICA registry or IICA database. Out of the given profiles, members will filter the independent directors and will appoint the same in the general meeting. If time permits, this is how the process will be. If shareholders are too busy, or if shareholders wish to transfer the responsibility from them to board of directors, it is possible. Nothing to worry. It is possible. They can do so. But after the appointment done by board of directors, it is the job of shareholders to ratify the same. To ratify the same. Ratification means, do you know what is meant by ratification? Validating the previous acts or validating the past acts. Doctrine of ratification is not applicable in case of minor. In Indian Contract Act, minor concept you might have studied the word called ratification. Minor used to take loan and gave a promise that, yes, now currently I am a minor, please give me loan. In 1 to 2 years I'll attain majority. After attaining majority, I'll come to you and I'll execute promissory note with respect to my past due. That is what we call ratification. That ratification principle is not applicable in case of minor, but here applicable. Whatever the acts done by BOD should be ratified by shareholders. Sir, all acts are, no, I am talking about this act. This independent director activity is there, no, this act should be ratified by shareholders. In general meeting, sir. In which general meeting, sir? In recent general meeting, I mean in a general meeting which they are planning within coming 3 months, or next general meeting, recent general meeting, whichever is earlier. In that meeting, shareholders has to ratify the decision taken by board of directors. Sir, what will happen if the shareholders didn't ratify, or if shareholders are in a opinion that whatever the person who is appointed by board of directors for the capacity of independent directors is unfit? They'll simply don't ratify, don't give approval for the appointment of independent director. Then what will happen? Independent director has to vacate the office simply, and again suitable person will be appointed in that position. That is the thing. Sir, why you are saying all these things? Yes, there is a big logic behind this. This is the process. So do you get the clarity relating to appointment process of ID? Appointment process of ID clear? Very good. Now I'll tell. Now listen. Company, shareholders, by passing ordinary resolution appointing independent director. This is how the process is going on. Am I correct or not? What is happening in the other scenario? Shareholders are delegating the responsibility to board of directors. Board of directors are appointing the independent directors. Afterwards, shareholders are ratifying the acts done by board of directors. This is the appointment process in a summarized form. This is the appointment process in a summarized form. Listen, our discussion related to here, resolution. Okay, sir, what is the resolution? Listen, say for example, company is considering the appointment of ID, and somehow company appointed ID in their meeting only. Or if BOD appointed the independent director, members gave the approval, everything is fine, no disturbances. Members appointed the ID first case, or BOD appointed the ID and members gave the approval also, everything seems to be fine. Max tenure is how much? Very good, you should be active. Max tenure is how much? 5 years is the maximum tenure. 5 years is the maximum tenure for independent director. Very good. 5 years completed. 5 years completed. Now company is again looking for the proper person for the position of independent director. Why? Because the job of independent director is a very divine role. He should be unbiased. He should act with honesty and integrity. Okay, so the job of ID is not a simple job, ma. So company is considering right person for the position of independent director. Company is considering a right person for the position of independent director. Majority of the members are in a opinion that the previous guy used to be there, no, that guy executed all the responsibilities in a perfect way. Why should we appoint the same person as the appointed for the independent director? Why can't we consider his appointment for the independent director's role? Yes, reappointment. I have already told you that reappointment once is allowed. First one is appointment. Now reappointment once allowed. Okay, allowed. But the critical point is, in order to appoint the same retiring independent director as independent director for the another term, you need to pass special resolution. So in the previous attempt, how you appointed ID? By simply passing ordinary resolution. No, but now you are supposed to pass. Whether you like it or not, it is immaterial. It is supposed or it is expected to pass special resolution for the reappointment of independent director. Why? Because for what purpose you are appointing ID? Excellent. That is the point. That is the main point we require in order to protect the interest of the company. In order to protect the interest of the company. That is why after 5 years, actually, even though with how much intensity or how much seriousness you may execute your roles and responsibilities, if you spend 5 years with the same group of people or bunch of people, somewhat licensing will be happened between the management of the company and the staff of the company and independent directors. Somewhat licensing will be there. That is why if you appoint the same person for second term, the job of the independent director is not same as the job of earlier job. Why? Because somewhat licensing will be there. IDs are prone to take biased decisions. Why? Because in first term, that much relation didn't establish it between employees or management of the company and the ID. But this is second term, and already 5 years they spend time together. This is another 5 years. Independent director is expected to take biased decisions now in the second term. But as per the original job role, independent directors are expected to take unbiased decisions. So his independence may be affected if you appoint the same person for the second term. Then the spirit of the law will be defeated, no? That is why, in order to protect the spirit of the law, they made this rule as a stringent rule. That is why, for the first appointment, ordinary resolution is sufficient. But for the second appointment, you need special resolution. That means more than 75% of the members should be in agreement with the continuation of same person as again independent director. Sir, third time also allowed, sir? No. Cooling period will be there. 3 years cooling period you have to spend. You have to stay out of the company, and after that again your profile may be considered. Okay, so this is what we call tenure, a term of up to 5 consecutive years, eligible for reappointment by passing a special resolution. Maximum term 2 years. 2 terms. 2 terms means 1 term 5 years. 2 5s are 25. 2 5s are 10. Very good. So cooling off period. After completion of 2 terms, 3-year cooling off period is required before reappointment. 3 years cooling period will be there. Sir, appointment must be approved by shareholders in a general meeting. First appointment can be done by board, then confirmed by shareholders within 3 months or next AGM. Both cases I have already discussed. You appoint, okay, it is okay, no problem. Appoint the same in your general meeting. If you are transferring your responsibility to BOD, first they will appoint. they will appoint. Next, you give your approval whether the profile is fit or unfit. Next, retirement by rotation. These kind of rules will not be applicable for independent director. Why? Because if you include independent directors into this retirement sheet or this rotation sheet, what will happen? In order to protect his employment or in order to secure his position, his integrity will be compromised. He used to have unnecessary chit chats or unnecessary informal agreements with the board of directors. Sir, we will work together, sir. Let's have a win-win agreement, sir. Let's convince shareholders for my second time reappointment, sir. So this kind of activities may be carried out by independent directors. That is why for a fixed term of 5 years, peacefully, if he wish to take exit out of the company, it is his choice. But for term of 5 years, his position is secured. And he don't need to take any kind of responsibilities with respect to this rotation mechanism and all. That is why independent directors are kept outside from the purview of this retirement by rotation concept. That is why independent directors are not liable to retire by rotation. Next, remuneration. Yes. This point I have already told you in previous session. I think I have communicated this point. Yes or no? Yes, maximum 1 lakh is allowed. Next one, reimbursement of expenses. This is anywhere allowed. Third one, profit related commission. If approved, many members will think that profit share and profit related commission are one and same. No. Profit share and profit related commission are not one and same. They are entirely different verticals. Profit share means you are getting some share out of the profit. Profit related commission means you are not getting share out of the profit. You are getting some sort of commission on the profit. Say for example, shareholders, in order to motivate directors in a monetary way, in order to push them or in order to motivate them, shareholders said that, sir, if our company's net profit for the upcoming year lies between 10 crores to 50 crores, we will give this percent as commission for all of you. If our profit 50 to 100 crores, we'll give this percent as commission. Likewise, why? In order to motivate the board of directors to work harder for the growth of the company. Isn't it a win-win concept? Company is getting benefited, BOD are getting benefited. Win-win concept. So that is why independent directors are allowed to take profit related commission, not profit related share. You have to be very careful with the wordings. He's talking about profit related share, profit related commission. Independent directors are allowed. They may frame MCQs on this kind of concepts also. For below items, IDs are not eligible. Profit related commission, profit related share, profit share not eligible. In fact, no director is eligible for the profit share. Why? Because shareholders are eligible to take the share in the profit. Profit related commission eligible. Next, ESOP is not at all allowed. Why? Because if you take the stock options and all, sooner or later you will become equity shareholder. That means you are become a related party. The job of independent director. Independent director is a related person or unrelated person? He must be unrelated person. How can you accept ESOPs? So, he should not accept ESOPs. Next, disqualification. Actually, cannot be promoter or related to promoter. This is the major disqualification. Why? Because his independence will be affected. And apart from this point, he must not be have had any pecuniary relationship with the company in the last 2 financial year or current year. Pecuniary relation he is talking about, not employment. Employment is current employment or past 3 years. With respect to pecuniary relation, he is talking about 2 years. Don't be in a confused state between these two provisions. Clear? Next one. Duties of the independent director is to uphold ethical standards and to act objectively and independently. Of course, from beginning onwards, we are saying the same thing. Independent director's duty is to act independently and to uphold ethical standards and to exercise responsibilities in a bona fide manner. Bona fide means malified, bona fide, two intentions will be there. Malified means bad intentions. Bona fide means good intentions. Simple. Next one. Resignation or removal. Oh, 100% allowed. If company's behavior is not liked by independent director, yes, he can take exit from the company by simply serving a resignation notice to the management. Or if independent director's behavior is not liked by company, they can expel this so-called independent director. So must give a detailed resignation letter, and for removal before terms requires which resolution? Special resolution, and an opportunity of being heard must be provided by shareholders or management of the company to the independent director. So these are the concepts which relating to ID, and ND also we completed. So today we completed only two concepts, ID and ND, but substantially important concepts only we have covered. Okay, so do you remember clause 47A of SEBI LODR? SEBI LODR clause 49 year, not 47 year. SEBI LODR regulations. As per SEBI LODR regulations, how many independent directors should be there in a company? Half of the board. Sir, no, sir. Actually, you told that for listed companies, 1/3 is enough. That is the provision substantiated by Companies Act 2013, not by SEBI. These provisions are substantiated by SEBI, ma. These provisions are substantiated by Companies Act. If you are an unlisted company, who is your husband? Companies Act only. You have to follow the rules stipulated by Companies Act. No need to follow the SEBI rules and regulations. If you are a listed company, you are having multiple husbands. One is Companies Act, another one is SEBI. According to Companies Act, you have to follow 1/3 rule, and according to SEBI, you have to follow half or 1/3, whichever is there, whichever is applicable for you. Tell me, if chairman is a executive, very good. Minimum half or maximum half? At least half. Very good. Minimum half. If chairman is a non-executive and non-related, tell me. Half of. Very good. Half. Half? Why? Why? Because he's a non-executive and non-related to any promoters or management of the company. So he is not a powerhouse. Then in order to counterbalance that, half is not required. Quarter is required. 1/3 is enough. 1/3 of total strength of board of directors enough. And if chairman is a non-executive, but he is related to promoters group, again same rule, half of the BOD should be independent. And after that, we came to know about who is the independent director. Independent director is a person who is not MD, WTD, ND, nominee director, nominee director. And what are the qualifications, disqualifications, appointment criteria, how the process, how the appointment process will be there, and all, and which resolutions required. Which resolutions required? Always ordinary resolution. Very good. Okay. Always ordinary resolution. Resolution depends upon the case, whether you are appointing a reappointing. In case of reappointing, ordinary resolution. Special resolution. In case of appointing, special resolution. Ordinary resolution. Reappointment, special resolution. Very good. Okay. What are the remuneration? What kind of remunerations ID can accept? Remuneration anyway he can accept. ESOPs he can accept. Profit share he can accept. Profit share and profit commission both are same only. Don't you know that thing? Both are same, huh? Both are not different. So profit share and profit commission both are entirely different. IDs are expected to accept only profit related commissions if any, not profit share and all. ESOPs shares, there should be no pecuniary relation current year or last 2 years. Employment current year, last 3 years. Should not be a KMP or employee or ex-employee like that. Okay. Resignation, removal. Okay. Anyway, we have completed the major topics. Okay, ID is the biggest topic in entire classification of directors. ID we have completed, along with ID, ND also, nominee director also we have completed. Right, that's all for today's session. Remaining will complete tomorrow. Alternative director, additional director, and all few topics are there. We'll discuss in a coming sessions. Okay, right. Thank you.